Learned Silk then urged this court to depart from its previous decisions pursuant to Order 6 Rule 54 of the Supreme Court rules on the manner of proof of non-compliance with the provisions of the Electoral Act in the light of the novel provision in Section 132 of the Act and paragraph 46 sub 4 of the first schedule to the Electoral Act. The learned SAN submitted that the assurances given to the public by the first respondents as a public institution that results will be electronically transmitted was dashed. It is his contention that the election ought to be nullified by reason of the gross misrepresentation by the first respondent based on the doctrine of legitimate expectation as applied by this court in Stitch and AG Federation. Citation supplied. The learned Silk concluded on this issue that given the introduction of technology into the collation process by the new Electoral Act 2022, the judicial approach and the attitude must of necessity be different from the analog past. He then invites the court to depart from its decisions on mode of proof of non-compliance with the Electoral Act in election petitions, as was the case in Nyesom Wike and Peterside, Okereke and Umahi, Shinkafi and Yari, amongst others. He urged the court to resolve this issue in favor of the appellants. In response, the learned senior counsel for the respondent, A.B. Mahmoud Hussain, urged this court to decline the invitation to override its previous decisions on the manner of proof of non-compliance because such invitation is not usually taken lightly by this court. He contended that the conditions for such application does not exist in this appeal, relying on VP Industries Limited and Cocoa Industries Limited, citation supplied. He contended that the appellant has not contended that the previous decisions sought to be departed from were given per incuriam or erroneous in law. On the argument that first respondent failed to electronically transmit results, he submitted that the only reference to electronic transmission of polling unit results appears in paragraph 38(1) of the guidelines published by INEC for the conduct of the election, wherein it provides that presiding officers shall electronically transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IREP portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IREP portal is only a public viewing portal and not a collation portal, relying on Oyetola and INEC, citation supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and result announced. In his argument, Chief Olanik Bekune for the second respondent submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the lower court was perfectly right and in order when it so held. He faulted the appellant's claim and basis of allegation of non-compliance with respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IREP in real time, not that it was not transmitted at all, and that the first respondent did not ensure that the results were collated on the IREP. He also faulted the appellant's insistence that the results ought to have been collated electronically on the IREP, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABS CS 145/2022, delivered on 23/1/2023 by Wite J of the Federal High Court, which decided that there is nothing in a combined reading of sections 47(2), 52, 65, and 62 1 and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections results. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by Section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. It submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of results or even electronic transmission of results. And that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Leonard Silk submitted finally that the Electoral Act 2022, the INEC regulations and manual, points irresistibly to a manual collation of results contrary to electronic collation touted by the appellants. The reason that by paragraph 93 of the regulations, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned Counsel Olanik Bekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peterside, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Leonard Silk, any arguments for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses, many of whom were incompetent witnesses, while purporting to prove allegation of non-compliance covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate evidence, the allegation of non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar, and INEC, all citations supplied. He urged the court on this issue against the appellants. In their reply brief, the learned senior counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46.4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act. That these new provisions deal with the new manner of transmission of results as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, sub 1 of the Electoral Act 2022. An election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below, and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real time to the IREF portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? The court below held that the IREF portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IREF portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collated at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IREF portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IREF deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collated with the ones transmitted into the IREF. Truth must be told, the non-functioning of the IREF may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREF is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collations from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREF portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1, the Nigeria Police Force, and 2, agents of political parties. End of quote. Paragraph 93 of the first respondent's guidelines and regulations reproduced above shows clearly that recourse to the transmission for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREF portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREF portal copy or a hard copy given to the Nigeria police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election result on the IREF portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My Lord, having failed to prove its petition by conventional method known to this court, the appellants urge this court to depart from several decisions of this court on ways of proving non-compliance. They have not shown that those judgments were reached per incuriam or that there was any miscarriage of justice. See some cases cited. Section 137 of the Electoral Act relied upon by the appellants for their failure to prove non-compliance in the manner we are used to provides, and I quote, "It shall not be necessary for a party who alleges non-compliance with the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance," end of quote. The above provision has not absolved a petitioner of the need to lead credible evidence to prove non-compliance. It states clearly that oral evidence may not be necessary if and only if originals or certified true copies manifestly disclose non-compliance. In this case, the appellants have not demonstrated the originals or certified true copies of documents they want the court to rely on. Given where such documents are tendered in evidence, it is to be shown that they manifestly disclose the non-compliance. On the whole, it is my well-considered opinion, which accords with the views of this court, with the court below, that the failure to transmit result to the IREF did not affect the result of the election. Accordingly, this issue is resolved against the appellants. The second issue is whether the court below was right in its interpretation of the provisions of Section 134 sub 2B and Section 299 of the Constitution of the Federal Republic of Nigeria as amended, in holding that securing 1/4 of the total votes cast in the Federal Capital Territory, Abuja, is not a constitutional requirement for the valid return of a candidate as duly elected President of the Federal Republic of Nigeria. In his argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in Section 134 2B of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of Volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134 sub 2B of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did. End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving same a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution, or any statute for that matter, a narrow and selfish approach should be avoided. The duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is tried that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and then resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellant subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules 2019 is not applicable in election matters. Learned senior counsel for the appellants falls the decision of the court below for relying on paragraph 4(5) of the first schedule to the Electoral Act 2022 and for failure to apply the provision in Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules. He submitted that the interpretation given to paragraph 4(5)(b) of the first schedule to the Electoral Act 2022 by the lower court in disallowing the testimonies of the appellant's subpoenaed witnesses will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the 3 senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 4(5)(b) of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be transferred by new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285 sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 45 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses in election petition proceedings is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bits, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in Oke and Mimiko, citation supplied. In his contributory judgment in the above case, Clara Ogumbiyi JS retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt to amend the petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134.1 of the Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation, seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of Section 285 sub 5 of the Constitution and Section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4(1) and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration of the time? The obvious answer is no. Such provisions like Section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citations applied, this court held that applications for extension of time to call additional witnesses and to file additional witnesses' statements after the prescribed period for presenting election witnesses should be allowed to testify. But as was argued by the learned senior counsel for the first respondent, which to circumvent the provisions of the law and the effect and purpose of Section 285 sub 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4(5) of the first schedule to the Electoral Act 2022. It is on this note that I hold that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' coalition agents at the court below. The appellants are aggrieved by the verdict of the court that the evidence of these witnesses were hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC, citation supplied, this court, per agim JCA, as it then was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, PW1 was not a polling agent. He was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or principal, having regard to the fact that no places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows, therefore, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22, who were state and national coalition agents of the petitioners, can only testify of the events in their units or coalition centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the coalition agents in this instant case, who are PW1, 2, 5, and 7, relating to suppression of votes, multiple thumb printing of ballot papers, entering of wrong scores results, disruption of voting, are inadmissible hearsay and are hereby discounted as end of quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Jumobi, and others cited. From the evidence on record, it is indisputable that PW 1, 2, 3, 5, and 7, who were the appellant state collation agents and national collation agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court has on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence analysis of PW 1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity, and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of the court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146, imprecise and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to wit Messrs. Adejo and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4 sub 1b of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their vehemence were sufficiently detailed. They also question the decision of the court striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in Section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present the election petition, 3, state the holding of the election, the scores of the candidates, and the person returned as the winner of the election, and 4, state clearly the facts of the petition and the ground or grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirement of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the audi alteram partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Ekonife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16 sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji citations supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yahya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners.
As the court places.
Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondent who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of highest votes in the election to be as contended here by petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court, by the petitioners, that the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I judge resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondents' averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134, sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than 2 candidates of the election, A, he has the highest number of votes cast at the election, and B, of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citations supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the result put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties and probably their counsel should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed.
As court pleases.
The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed.
As court pleases.
I shall make no order as to costs.
As court pleases.
My learned brother on my right will deliver his judgment. Thank you, sir.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023, Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed. And I also did not make any order as to cost, but affirmed the judgment of the lower court, declaring the second respondent, Bola Tinubu, as the duly elected President of the Federal Republic of Nigeria in the election of the 25th of February 2023. Thank you.
My little brother to my immediate left will deliver his judgment.
The lead judgment just delivered by my learned brother Okoro, JSC, has comprehensively presented all the points I made and the views I expressed at the conference of the Honorable Justices of the panel over the appeal. He has very proficiently presented all the views which I express in respect of all the issue in both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself. But I would like to say that the point raised by the learned senior counsel for the appellant, Chief Chris Uche Ezean, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting, attractive, but when taken along with the relevant provisions of the Constitution, as well as the Electoral Act 2022, is with respect to Chief Uche Ezean spacious. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named Presidential Election Petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it is coming up, and it is good that this court will make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My learned brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content erudite reasoning and the conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel of the appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Ian Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed.
Those accomplices.
Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is all and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Those accomplices.
Yes, Iroko. Agim, JSA.
Those accomplices.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Okoro, JSCFR. I completely agree with the reasoning, conclusions, decisions, and orders therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views. That the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed her certificate of reporter, bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above mentioned court because of the peculiar circumstances of this case and adopted as a deposition ordered to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court.
Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku Abubakar for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the district court or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said district court or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there. Candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in the election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have, very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part that the words can truly support the wordings used in that provision. That is how to read a constitution. Remembering that it is dealing with a dynamic system, a human society.
For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal. I call the next one.
SCV 937-2023, Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC respondents.
Appearances.
The Lordship, my name is P.I.N. Ikweto. My Lords, unfortunately, we have a type list of counsel, and by the time my colleagues brought it to the registry, they were told it was late. If Your Lordship allow me, can I submit that list?
Please, sir, submit it.
Thank you, my Lord, sir. And my Lords, with respect...
Judgment day, we don't go late to court.
I was here before, I was here by 8 o'clock, sir.
So that you won't be late when God will be giving judgment.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone. So I'll be late there.
So...
And I'm sure He will accept me when I get there, sir.
God will accept you.
I'm sure He will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is P.I.N. Ikwetu, and Your Lordship, with respect, we have, in line with Your Lordship...
I think we should start calling you Saint Ikwetu.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
Your Lordship, please. My Lord, Your Lordship know where we can discuss that, sir. My Lord, we've taken the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my Lord, Alex Ejesieme, SAN.
Azinge.
Yes, sir. Azinge is number 3, sir.
Yes.
Number 4, my Lord, is Alex Ejesieme, SAN.
Where is Azinge?
My Lord, Azinge is just beside me here. She's been here all morning with me.
Azinge used to be black. I don't know why she's white today.
No, she's always been fair complexion. Always. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a Lordship, please. Yes, sir. But she's been fair complexion all along.
It's okay. You're welcome.
Yes, my Lord, sir.
Leonard S.N. Ikweto, did you say Valerie is number 3?
My Lord, on the list, she's number 3.
But she's number 2.
She's number 2, yes, sir. Yes, sir. I just want to make it easier for my Lord, sir. The next, my Lord, is Mr. Alex Ejesieme, SAN.
Yes. Chike.
My Lord, there's a Chike A.O.B. Esquire.
Yes.
And my Lord, lastly, and in compliance with my Lord's directives, Ejiofor Onwaso Esquire. Your Lordship, the appearance with due respect is for the appellant in this appeal.
Yes.
Being pleased, my lords. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my lord.
Stephen
Adehi, my lord. Okay. Sir Stephen Adehi.
Leave that thing. Adehi.
Yes, my lord.
Yes.
I appear with my learned friends of the inner bar.
Yes, yes.
Al Hassan A. Umar, SAN, is number 4 on the list.
Umar.
Yes, my lord.
Yes.
And number 7 is Wendy Kuku, Esquire, my lord.
Yes. Yes.
Number 8, Jamiu Aguru, Esquire.
Where is Jamiu Aguru?
And finally, number 10, Z.U. Obansa, Esquire. Our appearance, my lord, is for the first respondent. May my lords be pleased.
Is that for the... Yes?
Sorry, my lord. My attention has just been drawn.
Tell those guys, tell them that this thing can amount to contempt of court, so they should be careful.
As copies.
My lord, the last person on our list, my lord, is actually number 9, Amira Hamisu, not Obansa. Number 9, Hamisu Esquire. Yes, my lord. Not number 10, my lord. Thank you very much, my lord.
1, 2, 3. Amira. Hamisu. Yes?
If it pleases my noble lords, my name is Akintola Makinde, and I appear with my colleague, Okpe Muritala. Your lordships, we submitted a typewritten list in the morning. Very respectfully, our appearance is for the second and third respondents. We are very grateful, sir. Okpe Muritala, my lord, is number 2 on the list.
Yes.
We're very grateful, sir.
Yes.
With profound respect to my lordships.
Yes.
Olumide Olujimi. My lord, my appearance is for the 4th respondent.
Yes.
Appearing with me, I'm learned friends. My lord, I'm sorry the next name is not on the printed list which you submitted.
Let me, okay, yeah.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi. We all respectfully appear for the 4th respondent. I'm much obliged, my lord.
For the 4th respondent.
Respectfully, my lord.
Yes. Well, in this appeal, we have, during conference, noticed that issues number 1, 2, 3, 5, 6, and 7 in this appeal.
Before now of reading in draft the judgment prepared and delivered by my learned brother Okoro JC, I cannot but concur with the far-reaching reasoning and the conclusion that has been postulated in the judgment to the effect that the instant appeal lacks merit, thus ought to be dismissed by this court. Having associated myself with that reasoning and the conclusion, I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
My Lord Jauro.
Well, I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother, John Ian Okoro JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is void of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My Lord Abubakar Jesse.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My Lord Agim Jesse.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Iyan Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rise.
All right, so we are live from the Supreme Court in Abuja, where breaking news is that the Supreme Court has affirmed President Bola Tinubu as Nigeria's president. Now, this is following the dismissal of the Supreme Court of the appeal by former Vice President and presidential candidate of the People's Democratic Party, Atiku Abubakar, seeking to nullify the February 25 presidential election of President Bola Tinubu. Now, in a unanimous judgment, the Apex Court dismissed Atiku's appeal for lacking merit and such affirmed the judgment of the Presidential Election Petition Court, which affirmed the election of President Tinubu.
Now, in the notice of appeal, Atiku had urged the Apex Court to dismiss and set aside the September 6 judgment of the Presidential Election Petition Court, which affirmed the electoral victory of President Tinubu. A 7-man panel of justices led by Inyang Okoro in determining the first issue for determination held that failure to transmit election results electronically did not affect the outcome of the election and could not warrant cancellation of the presidential election.
That's right. Now, the Apex Court also stated that Atiku did not produce alternative results of the presidential election that showed that he won majority of lawful votes cast to dismiss the ones declared by the electoral body, INEC. So in conclusion to that, the court has resolved that all the 7 issues distilled for determination in favor of Tinubu, stating that the appeal lacked merit. So that's breaking news just coming in. The Supreme Court has affirmed that President Bola Tinubu is Nigeria's legitimate president and that he won the election lawfully.
That's it.
Yep, this is a day that many of us have been waiting for, of course. as these proceedings have been, I mean, from February to October is a long time, to wait for this outcome. But hopefully this will put all issues to bed, and we can move on to governance issues. But I think one of the highlights for me was, of course, the fact that the certificate issue, the Chicago State University certificate issue, which was said to have been a potential smoking gun in the Supreme Court appeal, and of course the Supreme Court saying that they don't have the jurisdiction, and so just like that fresh evidence was not it didn't make any impact to the outcome of the proceedings today, and of course everything else, as we heard just at the end of this. The justice saying that, these are the same cases that you brought to the tribunal court, you're just bringing them back to the Supreme Court, they still lack merit, ultimately.
Yeah, well said. And for me, it was the fact that we got to witness this, that it was televised. And every Nigerian who could have tuned in or who decided that they wanted that option was afforded that opportunity and got to see how things played out from, start to finish. So it's a good day, depending on what side what side of the spectrum anyone falls on. But the point is the Supreme Court has affirmed President Tinubu as Nigeria's president and dismissed Atiku Abubakar and Obi's petitions for lacking merit.
That's right. Now, of course, one of the biggest issues after the February election was the issue of, the release of results, transmission of results, collation of results. So today, just some of the highlights, Justice Okoro mentioned, along with the other justices, mentioned that the testimonies of both Atiku and Obi state collation officers were merely hearsay. So I think that's another very big foundation for, especially a lot of the conversation that was happening around this election. There were so many things flying around social media, so many conversations about the collation process of the results. But ultimately, both courts, the Tribunal Court and the Supreme Court, both saying that, we didn't get to see hard proof. What we have is hearsay. And according to Justice Okoro, it was impossible for the testifiers to be in all parts of their states at the same time to prove that their case there was electoral fraud. Another major issue, of course, is the 25% votes. The Supreme Court upheld the appeal court's ruling on the FCT. And again, another sort of huge moment in our constitutional electoral law, really, this ongoing debate about the FCT being an independent, is it 25% plus FCT? Is FCT part of the 25%? Yeah. This back and forth that had been going on. So it'd be interesting to see where we're going to go with this. We have 4 years to sort of look back at our electoral laws and see where the loopholes are, where the gray areas are, so that we don't have a recurrence of some of the sort of misunderstandings and gray areas.
Misunderstanding is the perfect word, and I think from what we're looking at, there might be need for more clarity about the process. Knowing what live transmission means, IREV and whatnot, collation, and everything that was stated. So I think from what we heard, we're going to have to see some more clarity, whether it's from the electoral body or regarding our electoral laws, and time will tell. Yeah. Based on the outcome of what's happened today.
And I'm glad you mentioned the IREV, because one of the main points was that point number one, when IREV fails, it does not stop the collation of results. Mm-hmm. And point number two, the non-function of IREV does not reduce voters' confidence. That's a big discussion on its own. That's open to a lot of debate because, of course, we've seen the videos time and time again. We were reassured. IREV. A lot of people's confidence about the credibility of this election was based on these, what was supposed to be revolutionary, digitization of this election. But, at the end of the day, the Supreme Court is coming back and is saying that, and is reaffirming what the Presidential Tribunal had affirmed, which is that, the non-function of IREV does not actually reduce voters' confidence. And that is according to the law of the land.
Yeah.
All right, so if you're just tuning in, we're just keeping you abreast with breaking news from Abuja. The Supreme Court has affirmed President Bola Tinubu as the President of Nigeria. All right, so we're now going to bring in the conversation to the studio, back to Lagos, and it's great to be joined by Rise News analysts who, of course, will be helping us to dissect this is a huge moment in Nigerian history, also in African history, of course. You know, we spent a lot of time breaking down the Kenyan election and what happens when there's disagreements and when people, various parties question the outcome of an election. So there was, of course, we saw that happening in this election, especially with the introduction of digital technology into this election. So, very soon we're excited to be joined by our analysts so that we can further break down these issues. But again, just to go back to some of the issues, all right, shall we take a look at what's happening in Abuja currently as we get some initial reactions?
The judiciary has done well. It means that democracy is getting matured in Nigeria, and we are happy with that.
Many thanks.
Thank you.
Congratulations.
Okay, so we've just heard from the APC chairman, that's Ganduje, telling us that democracy has matured in Nigeria. That's his first response to this breaking news. So let's come back into studio. We're here live from Lagos, where Arise News analysts Dayo Shobowale and Emmanuel Efeni join us to further dissect this huge moment. This is probably the biggest news in Nigeria today, this week, this month. Good afternoon, warm welcome.
Good afternoon, Vimbai. Good afternoon, Cynthia. Good afternoon, Dayo.
Good afternoon.
Yes. Well, the Supreme Court has delivered its judgment. The lead judgment read by Justice Ian Okoro, and of course the other justices concurred in their own submission when they gave their own response. But clearly, a closure will be put on the presidential election of February 2023, and the Supreme Court particularly warned nobody should attempt to come back to the court to want to ask the court to review itself. But clearly the main issues that were raised, like you rightly mentioned, the Chicago State University certificates or deposition, which perhaps Atiku and PDP thought was a smoking gun, a silver bullet that will turn the tide in their appeal. Clearly, the Supreme Court hammered on the issue of jurisdiction, since it was not a document that was pleaded at the trial at the lower court, in this case at the Presidential Election Petition Tribunal. There was no way those documents were going to be admitted. So clearly, those documents did not play any role because there was the issue of jurisdiction. They couldn't even admit those documents. Of course, the pronouncement of the Supreme Court Justice on IREV. Yes, IREV is not a collation device. That distinction must be made, yes? And they made that distinction very clearly. So not uploading in IREV does not mean the results were not available. They were available in physical form, which all party agents had at the end of the election. And so the IREV, perhaps too much was attributed to IREV as a magic one. And come to think of it, IREV, that you can view the results real time, to use the term of INEC. You view the results real time. But it's not an alternative collation device. That's what the Supreme Court has just made us to understand clearly. So the fact that results were not uploaded on IREV real time does not mean that there was no result to be collated. There was results collated, and the figures were used to announce the result of the outcome of the presidential election. perhaps one that was once very straightforward matter was the issue of 25% of FCT. The Supreme Court just made it look very simple, adopting the position of the Presidential Election Petition Tribunal that FCT is not a super state that will overrule. If they just adopted the position of the Presidential Election Tribunal, so 25% of is just what it is. You treated Abuja as one of the states of the Federation. So you simply just add it. If you add 25% in 24 states, it becomes 25. You had nothing more, nothing less. So no special status on Abuja as the other parties try to canvass, especially the Labour Party, that the president did not score 25% in Abuja and as such, his election is not valid. Well, the Supreme Court has dismissed that, adopting the position of the Presidential Election Tribunal. And, of course, proving that there was malfeasance, malpractice during the election. You have to prove it. And the Supreme Court was particularly clear on the Labour Party's submission. They did not come with first-hand witnesses. They brought, and to use the word of the Supreme Court, somebody who is like an octopus, octopus supervisor to court, who is telling you what happened in this several polling units where but nobody was brought from who witnessed these malpractices they were claiming. So I think it's also a lesson for the political parties that if you want to, you must know how to prove your malpractice if it happened, not just assuming or reporting to the courts. The courts deal with facts, and that's what the justices have just confirmed. Not speculation, not somebody who did not witness the situation, quoting people who are not there as witnesses. So I think the judgment, and that's the beauty of delivering these judgments live. But for that, somebody will ask me to wait until I read the full judgment, see the CT6 certified true copy, but we all saw it. The lawyers, the non-lawyers, observers, analysts, and newscasters. Yes. We all listened to the judgment, and I think there was clarity in the judgment, and I'm not sure many will argue with what the Supreme Court justices. Of course, if you want to review, you can review, but of course, this is the final. This is it. The final bus stop, as it were.
Absolutely, please, Mr. Shobowale.
Yeah, spoken at length. You see, I will say the judge said that there must be an end to litigation. So there is a full stop now, because the Supreme Court is the Supreme Court of the land. I will quote, put across the quotation. They say the mills of justice grind slowly, but they grind exceedingly fine. I'm not surprised at the decision, and I will tell you what I've based it on. There were when INEC submitted its defense of how it conducted the election, it made two claims which jarred Nigerians, which was that, you see, although it is to deliver the result electronically, but it does not have to be sequentially before it announces the election. It was in its submission to the court. That is number one. And then a court ruled later, a court of appeal ruled later, that the regulator of the election has the discretion to do what it likes with the rules. Get me? So the moment INEC has submitted that it doesn't have to download immediately.
Mr. Shobowale, I'm so sorry to interrupt, but of course you'll get a chance to finish. Okay, please hold the thought, because we do have to cross live to Abuja right now to see what's going on after the Supreme Court has affirmed President Tinubu.
Credible means believable. Why shut out the people for the right the law has given unto them? So I was very glad that the Supreme Court pointed it out, that non-uploading of the result reduced the confidence of Nigerians in it, meaning that it cannot be presumed to be credible because Nigerians were shut out in it. So I loved that particular part.
Thank you.
Thank you.
Mr. Shiboy, that was raised now that it reduced the confidence.
No, I don't know. I don't think that has reduced the confidence of Nigerians. Maybe you don't listen to me. What I was saying was that in defending how it conducted the election, INEC, you see, we all thought the the result would be downloaded electronically, just like that. But in his submission, he said it's not duty bound. You get me? To download the results electronically before announcing it, or announcing it before downloading it electronically, which was what he did. And then a court of appeal had ruled earlier on a case that the regulator of the election has the discretion to interpret the Electoral Act as it is convenient for it, which is what really happened, and which is what the appeal court for the presidential election, which is what they upheld. So it is not strange to me. And then on the issue of Abuja, as 25th state, you see, the Court of Appeal judge went into the memorandum of association preceding the election. And he said, look, the spirit of the Constitution is there. That you cannot say, because somebody has not won in one federal capital territory, even if you have won the majority of the seats in the 36 states, you say you cannot win an election. That is it's not logical. So I respect the reasoning behind the decisions of the courts, in not wasting time, in putting an end to litigation, and allowing us to continue with our political life. It's a good development. Thank God nobody can appeal again. So we have governance for 4 years. And I'm happy with that.
We certainly hear, but Mr. Finney, I'm wondering, based on what was stated, like IREV and the FCT 25%, do you think we're going to need to see the need for more clarity as we move forward with our democratic process for subsequent elections? Well,
the issue of the 25% of votes, I think is very clear. And because the appeal court sitting as the presidential election petition tribunal dilated seriously on that. And I think the Supreme Court wholly adopting that position had put to rest the issue of Abuja and 25%. There's no argument about that anymore.
Yeah.
But the issue of what you said, INEC can interpret the law. I don't think that's what this one was saying. On the issue of mode of transmission of result, because the law did not state expressly that INEC must transmit electronically. So INEC is
discretion.
Yes, it's in a position to use its discretion to transmit in whatever manner it chooses.
That was how he defended the election.
Yes, but the issue of confidence in INEC, whether after all this, what we have gone through, whether Nigerians have more confidence in INEC now. I think that was Kenneth Okonkwo, lawyer, actor, member of the Labour Party, was saying that the Supreme Court also said something that the fact that INEC did not keep to its own promise of transmitting result on IREV real time will also affect the confidence of Nigerians. And I think that was also a spillover from the judgment of the Presidential Election Petition Tribunal. We stated that though INEC made promise, gave assurances that it will transmit the result real time, but it went further to say that INEC assurances are mere promises. But some other people will say, yes, henceforth, INEC's assurances that are not based on the law, that gives it where it has discretionary powers, should not be taken too seriously. So my own recommendation, when INEC gives assurances that are not based on the electoral act, then they should prepare for all scenarios. Because I think the hue and cry you are hearing from the other part, oh, INEC promised. Yes. They gave assurances in London, in Nigeria, they were giving assurances. But at the end of the day, they did not transmit those results from the polling units into IREV real time. But the justice have said the fact that they did not do that does not mean the results were not available, because they were available in hard copy, which all the parties had a copy of from every polling unit, because you had your agent there and they were given.
INEC
so
can always use its discretion.
Yeah, so INEC can use its discretion.
That's right.
And perhaps some of us will say, maybe INEC has the right to change its mind.
You know what, on that note, Mr. Shobal, I want to bring you in because, you know, prior to this, to the Supreme Court hearing, there was a lot of discussion about the fact that is this outcome going to be an outcome of technicalities? Based on what Mr. Feni just said, it almost feels...
I've not read his judgment.
Yeah, no, I'm just looking for your take, because some people may come in and say, as Mr. Feni is saying, well, INEC promised, and you know the court is saying that, well, this isn't written in the Electoral Act; it's an INEC promise. So that seems like a technicality to me.
No, but I've not even said it's technicality. It is not technicality.
It's an interpretation of the law.
There's nowhere it says that in the law that INEC must transmit in this manner. Mm-hmm. So INEC can transmit.
So
INEC, that is not technicality as far as I'm concerned. The Supreme Court, flowing from the Presidential Appeal Election Petition Tribunal, I think they just stated in law.
Yes.
There, well, maybe lawyers will have.
Law. Maybe stating the law is not technicality.
Maybe lawyers will have.
Maybe
some lawyers will have a different, but to me, I don't think there's technicality there.
Of maybe the time for you to bring in this as lapsed and things like that, while leaving the substantial issue on justice. That is what people are skeptical about. But on this occasion, they interpreted the law. You get me? Listen to INEC's defense. Listen to what the political antagonists were saying, and took a decision on point of law and procedure.
Indeed. Oh,
yes.
Mr. Fini, you mentioned earlier that it was stated that INEC's promises are basically assurances, and as long as it's not...
The assurances
are promises. Which one is it? Assurance, promise, I guess it's interchangeable at this point.
Yeah.
Yes, but my question now is, based on that, I'm being told to pause. Okay. We have a video of the president reacting to the Supreme Court ruling. Let's take that and we'll continue our discussion here in studio.
Thank you, sir. Congratulations, Your Excellency. Your job is secured. Scope 2. Your job is secured. Congratulations, Your Excellency. Gentlemen, congratulations to the President. Having been confirmed by the Supreme Court as the 5-star general. Yes. As the Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria. Thank you. Congratulations, Your Excellencies. Thank you very much. Amen. Amen. Inshallah, all our renewal shall come to manifestation. Amen. All your job is secured. Let the president.
I think the hashtag for today will be your job is secured.
Your job is secured.
Based on what
must
the
be a sign of
president
relief for many, but expected.
Yeah. I don't think we expected any different reaction. But Mr. Shibwell, you want to talk about this before we go back to what we were discussing?
Which one?
This reaction of the president to the judgment.
You asked me what you want to. You asked me a question.
Okay. What do you make of what you see? Are you surprised? Are you thrilled?
Why should I be surprised? It's even subdued that he even seated. You get it?
Good. Okay. Mr. Ifeni, any reactions to hashtag your job is secured?
Well, the president I'm not sure that he was too anxious this time around compared to the verdict of the Presidential Election Petition Tribunal, because basically at that level, the judgment was extensively espoused, and I'm sure he wouldn't have been more ruffled so much today. But you can see it was sitting easy, although some of the aides there will want to go overdrive. haven't been confirmed as a 5-star general. Well, the president was confirmed as the commander-in-chief of Nigerian Armed Forces on May 29, 2023, and that has not changed up to now. So it wasn't the Supreme Court that just made him. So, but of course, he expects someone to go overdrive. Well, they're all happy, and I think the president should. Yes, the president should, of course.
I'm sure privately he will celebrate. And thank God.
Yeah. So of course,
after all the legal gymnastics and mortars and battles, everything has come to an end now. So we can have some respite and peace in the land.
We can say democracy in progress, and of course, it's part of the democratic process that people who are not satisfied with the outcome of the election will challenge the outcome. And the presidential candidates of 3 political parties have done that at the Presidential Election Petition Tribunal, and also explored the option of taking the matter to the apex court in the land, which is the final arbiter on this matter, and they have just done that. President Bola Ahmed Tinubu confirmed as president of Nigeria, and that is the end of the matter.
Yes, God's case, no appeal. You know, some of these downfall drivers, you see slogans they put there. This is now a case of God's case, no appeal.
Really?
Yes, because the Supreme Court has ruled, and the judge has said in the Supreme Court, litigations must come to an end. So let us face politics now.
Well, this is man's case. Let's not go back there. It's not God's case.
I did not write it.
This is not God's case. So let's leave it at the level of
God's case, no appeal. That's what I read.
There is a reaction from Chief of Staff President Femi Gbajabiamila, who said the victory means the beginning of governance, which is, that's an interesting response. Seeing as you're so, in support of it, why are you so strong in your feel that surely governance should have started from inauguration?
No, let me tell you this. This is the democratic process that has gone full length. And we have to thank God that it took place in a very peaceful atmosphere. The lawyers have had their day in court. The judges have given their judgment. That is democracy. Democracy is based on the rule of law. Get me? And once the Supreme Court interprets the law, that is the end of the matter. So we go to the political system and allow those elected to implement what they have promised to the people. And those who have lost should, bury their asset and wait for another election 4 years' time. The electorate is the chief judge in this matter. It's the electorate that picks those it wants to reward who have performed well in office, it will re-elect them. Those who have not performed well, who have not delivered on their promises, they jettison them. That is the beauty of democracy. And people should behave like sportsmen. No, you don't win every time. Get me? It's like sports. It's like sports. The spirit of the competition matters in that the winner must be accorded the honor due, because in a democracy, the majority will have its way, the minority will have its say. That has played out splendidly. You get me? From the electoral, from the ballot box, you get me? To the announcement of the results, to appeals, to petition against the result, against INEC. INEC too has defended itself, has gone to Court of Appeal, has gone to Supreme Court. We have gone through the gamut of the entire democratic process. I'm proud to be a Nigerian who have witnessed that. So I'm happy. So let's go on with politics. Not yes.
Well, Mr. Thank you for raising your point, of course. Yeah. Mr. Feni, I want to go back to what you mentioned earlier about assurance and promises, and that as long as it doesn't, please correct me if I'm misquoting you. You said the promises are simply assurances, or assurances are simply promises. Which one is it? First of all, let's establish that.
INEC's assurances are mere promises.
Are mere promises. Thank you.
From the appeal courts.
So, when you hear that, and you think about the everyday Nigerian that held on to INEC's word, the assurance or the promises that they gave, and now they're hearing that as long as it doesn't line up with the Electoral Act, they're not bound to that. What do you think that does for subsequent promises or assurances that the electoral body might make to the electorate?
Well, let me first talk about the point Femi Gbajabiamila made, the Chief of Staff to the President, on governance starts now. Yes, because as long as you have these cases in courts, it's a form of distraction. And perhaps that's why there's been this conversation about how we can ensure that all election cases are dealt with, finalized before swearing in. And it is an option Nigeria must view very seriously. Because if Kenya can do it, why can't we do it? So when a president has been sworn in, the court case, was sworn in May 29, and this is October 26. How many months? So it's a distraction. So now that has been put to rest, the president will concentrate, and his team, they will concentrate fully on the issue of governance. But the issue you are talking about as for INEC, I don't think we should just throw INEC under the bus. Because what INEC did, perhaps we just attribute it to the chairman of INEC, making a promise which it did not keep at the end of the day. They said there were glitches.
What they call?
They talk of glitches. That was why they couldn't keep that promise. So perhaps also going forward, INEC must promise what it can deliver. And perhaps we need to take another look at the electoral law 2022 also, so that some loose ends, because if the law says this is the mode INEC has to transmit the result, then it will work towards that, and it has to be that, or that election will not be valid. But in a situation where it has discretion, of course it can use its discretion, but the problem is when you promise one thing and you don't deliver on that, and you do something else, that is where the problem is. And INEC cannot be faulted on grounds of law because it has discretion, according to the law, to transmit the result either electronically or manually. But if we want things to be clear-cut, then perhaps we have to amend the constitution to determine that, look, this is the mode through which INEC must transmit its result. On election day, from the polling unit, the result must be immediately available in IREV so that every Nigerian can view the result. You can sit in your home and view the result from your polling unit, whether it tallied with what was announced when you were there. So I think that's where we should be working towards. This election has been concluded, so whatever we think are the infractions or the shortcomings, we must sit down and look at the law to plug all the loopholes, because politicians are also crafty. Especially not just Nigerian politicians. Of course, Trump is a crafty politician.
Mr. Shabala, very quickly, I just want to, I know you have a comment, just to buttress what Mr. Efenia said. Counsel to PDP, Mike Ozekome, has commented, and he said Nigeria is a work in progress, which chimes into this conversation. So I'd love to know what is the work?
Precisely what I was going to say. Democracy is work in progress. I see our election has walked the gamut of the entire process. It has been interpreted at the final end. So what we can do is a postmortem on what transpired. You get me? And I want to add something. You see, it's not as if the rules are faulty. You get me? You make rules. The Constitution is there. It is when the workings of the Constitution are in place that you know its shortcomings or the interpretation of various modes you assume as given. Do you get me now? It doesn't mean that we need to tinker with the law every time. But this is, it's a dynamic situation. It's a dynamic situation. We learn every day. And where there is ambiguity in the rules for the elections, we sort out the ambiguities and clear them so that there is clarification. That's all you need to do. You get me? If the government likes, it can retain INEC. If it does not, it can reconstitute it. It is an ongoing work in progress. Democracy, we learn by the day. Before in England, they had no written constitution. They didn't have a Supreme Court. They just had it some years back. Because 80% of the constitution was unwritten. So we learn, but our own is so much well written that you see, you need to interpret almost everything. Just like the judge gave a lecture in the Court of Appeal on the inclusion of Abuja as a state or as a federal capital territory. So we learn by the day. And there's something called constitutionalism, which is working according to the dictates of your constitution. That is what we have achieved. You can't please all parties, because we contested at the election. Some people lost. You get me? So some will jubilate, some will sulk. That is the nature of politics until the next election. That is what democracy is all about.
And speaking of the next election, of course, we're just counting down to off-cycle elections coming up very soon by Elsa Imo State. Mr. Feni, what impact do you think this ruling will have on what we're going to see in those, very significant elections that are coming up?
Well, the off-season elections are usually opportunity for INEC to not only correct whatever shortcomings there are in past elections, but also to even test run new ideas. So INEC has, I don't want to use promise, has said, has said that...
You have to say something.
No,
the person conducting the election.
INEC has said that
the promise is delivery. It's service delivery.
Will work. The election, the results from the polling units in this off-season election in Kogi, Imo, and what's the third state now?
Bayelsa.
Bayelsa, yes, will be transmitted, will be there on IREV. So, but I'm sure the politicians, they know better now what not to trust, prepare for all scenarios, so that you don't say, oh, INEC said so and did not do so.
You see,
just prepare for us. Because before IREV, we were doing elections, and politicians ensure that they get copies of every result in every polling unit. Of course. It's available to all political parties participating in the election.